Good morning, everyone. Thank you for joining us. I am Elise Donovan, the CEO of BVI Finance. Thank you for joining us for another BVI Finance Breakfast Forum. Today, we are diving into a crucial topic: how to turn your suspicious activity reports into game-changing intelligence. In this session, we will unpack what a good suspicious activity report really looks like, how to share effective, memorable examples that stick, and offer practical, actionable moves you can use to immediately upgrade your reporting quality. You will learn to better connect the dots across the customer due diligence, enhanced customer due diligence, risk assessment, and monitoring processes. And ultimately, we hope you will gain a sharper eye, a stronger narrative, and inspection-ready confidence in your filings. We are so pleased to have two very senior experts joining us today from our regulator and competent authority, the BVI Financial Services Commission and the Financial Investigation Agency. First, let me welcome Mr. Glenford Malone, the Deputy Managing Director Regulation at the BVI Financial Services Commission. Mr. Malone was appointed the Deputy Managing Director Regulation in January 2022, and he's responsible for implementing the Commission's overall regulatory strategy. Mr. Malone has over 2 decades of experience within the regulatory environment, having served many roles such as Senior Regulator, Deputy Director Investment Business, and prior to 2002 was Assistant Registrar of Mutual Funds with the former Financial Services Department, now the BVI Financial Services Commission. Mr. Malone is a certified anti-money laundering specialist and is a trained financial examiner in FATF methodology on assessing compliance with the FATF 40 recommendations. He also distinctly holds a Master of Laws with distinction in Law and Finance and a Bachelor of Business Administration, Economics, and International Business. Next, I am also pleased to introduce Meglisa Cupid. She's the Deputy Director of an Analysis and Investigation Unit at the Financial Investigation Agency. Meglisa is responsible at the Financial Investigation Agency for oversight of the unit's core functions under the Financial Investigation Agency Act for 2003, which includes suspicious activity reports received by the agency. Ms. Cupid obtained her Bachelor of Laws degree from the University of West Indies, a legal education certificate from the Eugene Dupuis Law School, and I know I messed that up, and completed a Master of Laws degree in International Corporate and Commercial Law from King's College, London. Ms. Cupid has approximately 9 years relevant experience in anti-money laundering, countering the financing of terrorism, countering proliferation financing, and she also is trained as a third-round AML CFT assessor and was a receiver for Haiti and Suriname's mutual evaluation reports. Ms. Cupid also holds an ICA International Diploma in Anti-Money Laundering. Please help me welcome our speakers for today, Meglisa and Glenford. Please open your mics.
Yes.
And go ahead. Okay. And I also want to thank all of you for joining us. This topic is one that I think everybody in the agency, in the industry, I should say, is very familiar with, and it's also a topic that's very relevant as we go through our process with the Financial Action Task Force mutual evaluation reports, getting our requirements in place, etc. So I'm going to start and ask Mr. Malone the question, why are we here? And what's the connection with AML, CFT, CPF? And I think everybody knows the acronyms. And what are you trying to achieve with this conversation on suspicious activity reports today?
Well, thank you, Elise, and good morning, everyone, and thanks everyone for attending today's session. So, what we want to achieve is continue to demonstrate a high level of effectiveness in the quality of SARs that are filed to the Financial Investigation Agency. And that is because under the international standards, high quality of SARs then leads us into the arena of better investigations, better prosecutions, better ability to confiscate asset, which means taking the proceeds of crime, which is ultimately what we all here trying to do, take the proceeds out of crime. What we want to do is to make sure, in keeping with the standards, that we continue to show effectiveness, we continue to satisfy the FATF requirements. As one would know, coming out of the FATF process, there were some recommended actions, which includes for us increasing the quality of SARs, specifically in the higher risk sector of TCSPs, investment business, and VAS. And we've done considerable amount of work, both us and the FIA in collaboration over the course of the last year or so. And this is a next facet of that activity. So we're really here just to give folks, as you say, insight, the ability to understand what we're looking for, both from the quality of SARs and, as you say, what we are looking for as the FSC when we do inspections.
Okay, thank you very much. And I forgot to do housekeeping, and essentially you can go ahead and start placing your questions in the Q&A, and we'll get to them um, towards the end. And if there are questions that are prompted out of something that both Mr. Malone or Ms. Cupid have said, please feel free to put those questions in the Q&A section and we will respond to them accordingly. The topic focuses on the quality of suspicious activity reports in high-risk sectors, such as TCSPs, IBs, and VASP. From the Financial Investigation Agency's perspective, what does a high-quality suspicious activity report look like? And what's your expectation on the content of a SAR? And how do you measure quality? I know that was a big question.
Thank you for the question, Ms. Donovan. I'll start with your last question first. How do we measure quality? We have established a criteria that we would look at to assess and determine quality. And basically, our expectation is that the filers would actually include in their SAR those core areas that we deem necessary to be able to analyze and produce actionable intelligence, meaning that we can make those disseminations to law enforcement and have the potential investigations and potential prosecutions, as Glenn Ford indicated. If you'll permit me, I would actually go through the criteria. So hopefully the audience can have an idea of what we look for in the SAR. And by the agency doing this, hopefully this can improve the quality of the SARs. So one of the first things we look for when we receive a SAR filing is basically who is the suspect or the target. Like any investigation, you must have Sorry, seems like I was put on mute. Can you hear me now? So this information should be clearly stated in the SAR form, and not just the SAR narrative, but also there are areas of fields in the SAR form that should be filled in. Secondly, one of the other things that we look for is the account information if applicable. So for instance, the name on the account type, and the balance as at the date of the report is important to be included in the SAR form. That is, of course, if it's applicable to your particular sector. Another thing we look for is a unique identifier. This is with respect to the suspect or the target, the name, the address, an ID. At least one of those things should be incorporated in the SAR filing. Another aspect we look for is if there are transactions involved, the dates of the transaction, the amounts of the transaction. That is crucial information that we need to see in the SAR filing to be able to analyze and assess the particular SAR. Another thing that we look for is, and this is crucial, the reason for the suspicion. So when you look on our SAR form, there are actually specified reasons for suspicion that can be ticked off on the SAR form. Sometimes the filer would indicate which particular offense or suspicious activity it is, but sometimes they don't. It is important for them to indicate that on the form. Not just put it in the SAR narrative, but also indicate, tick off whatever suspicious activity it is, whatever offense it is. This further facilitates our analysis and brings context to the matter. Another crucial aspect, explaining why this SAR filing is suspicious. We often get, well, more than not, or more often than not, we receive SARs from some sectors that they would file a SAR, but they don't really explain what the suspicion is. This is crucial for us to be able to assess the suspicious activity. If there's no suspicion, then really and truly it would not constitute a SAR. This suspicion must be explained. I can't emphasize that enough. Why are you filing the SAR? Another aspect that is crucial is the timeliness of the report. So we've seen SARs that, for instance, a suspicious activity might have taken place, say 2023, but we only receive a filing, say this year. By the time we analyze, and if the suspicion is substantiated, we make those disseminations to the relevant authorities. More times than not, they would come back and say, well, the information is too dated for them to pursue anything further. So timeliness of the report is crucial from the suspicious activity. That way we can, once it's filed within a timely manner, we can then make more timely disseminations, which can then have more of an effect from the investigatory perspective. And another thing that I would highlight is from the MLRO perspective. When we receive SARs, we don't always know whether any internal investigations were conducted. This is a crucial component because the MLRO has a responsibility to also conduct their internal investigations, whether they're reviewing, but once the report is made to them, whether they're reviewing the client files or they're assessing CDD or ECDD information, which will include source of wealth, source of funds, to see if it aligns with the transactions being made. That is crucial information that can benefit us in our analysis. And if it is, if those steps are being taken, then it would be useful for that to be included in the SAR narrative. That is a general overview for both ordinary and virtual asset SARs. There are some unique things for the virtual asset space that I would also like to highlight that should be included in a SAR. For instance, the transaction hashes. There have been instances where we received SARs that did not include transaction hashes. It is crucial for them to include that information because that then facilitates the analysis. We then know where to look in conducting our analysis. Another thing is the wallet and the wallet type. Indicating what type of wallet is being used is important, whether it's a hot wallet, a cold wallet, a multi-signature wallet. That sort of information is important for us as well. For the investment business, I would say one of the things that we notice, like for instance, if it's a third party investment. So the investment is being made on behalf of a third party. Sometimes the KYC isn't included on the third party individual. That sort of information would be also beneficial for analysis. So the name, address, any unique identifier, that sort of information would be very useful. I'll stop there, Elise. Thank you.
We already have a question, and I need to apologize. It seems that there's a technical glitch and it's not allowing us to let in more people. So they're trying to resolve that technical glitch. We are not sure if it's related to this cloud incident that's happening, but the issue is trying to be resolved. And so we sincerely apologize. It's saying that it's at capacity, but we should have more than 200 people be able to enter the forum. The question is, should supporting documents be provided with the information reporting forms?
Definitely. Supporting documentation should be provided with the SAR filing. All that will feed into our analysis. So definitely, if there's supporting documentation, please provide those.
Okay. So how does the FIA provide feedback on the quality of the SARs? How do you provide that kind of feedback?
Okay, so currently we are actually working on implementing a process for providing feedback on the quality of the SARs, because we've realized that this is a very important aspect of what we do. So we're in the final stages of doing that. So in short order, I would say by the end of this year into early next year, the industry should be receiving feedback on the quality of their SARs.
Okay, that's good. We have a next question. Please explain how the following matters other than SARs should be reported to the FIA. Incomplete due diligence, declined, turned away business information report, matters that are not suspicious but are noteworthy.
Yes, that's a good question. So situations or circumstances that don't raise a suspicion, you can utilize our information report form. That's really the purpose of that particular form. So you can fill out that form, submit it to the FIA, and then we can use that intelligence where we would store it in our database, and it could be used in other future matters for analysis. So definitely, if there's information that could be beneficial, you can share it on the information report form.
Okay. Mr. Malone, from the FSC's perspective as the supervisor of TCSPs, IBs, and VASP, how do you ensure that these entities have the appropriate mechanisms for filing quality suspicious activity reports?
So thanks, Elise, for the question. So we look at it from two perspectives: a desk-based review if we undertaking one, and physical inspection, which through our compliance inspection unit. I should mention we probably in the midst of a desk-based review for SARs. We did one last year, which turned out pretty well in terms of the level of compliance by licensees. We're going to be doing a next one. So some people may receive letters up to this week asking for certain information surrounding that, focusing on the IB sector and TCSP sector. In terms of the inspections now, when we're looking at SARs and we go into to inspect, we're not looking at the actual SARs submission itself. What we're looking at is synopsis, snapshot of what you're filing, whether you're filing it timely, whether there's sufficient information to identify a SAR, and as I think what Miglisa mentioned, whether the MLRO is actually reviewing the suspicion and when that suspicion is identified from that moment in time to when an actual filing is made. So the issues that we tend to see, and I think from our perspective, licensees tend to have very robust procedures in relation to SARs. They're well written, they have them. Where they tend to fall along sometimes is the timing, as Miglisa says, and the quality of the information. What we tend to look at then is, well, what may be causing that, whether or not you appropriately training the staff, whether the frontline staff knows what a suspicion is, how often do you train those frontline staff, and it's then unique to the type of activity and clients that you are performing the service on. One of the most significant issues that we think impacts on people's ability to file a quality SAR, and what we look at is whether or not people actually have a proper monitoring mechanism for clients in place. And the reason being is, if you don't know your client and you don't monitor your client, you don't know what is suspicious. So it's a chain link. If you're not doing one, you can't do the other. So if you're not properly monitoring, then how do you know when your client is suspicious? I know, for example, let me just say, in relation to TCSPs, the great majority of the clients, the legal persons, the companies are what they would call holding companies. But they have clients that are substantive clients who have other activities. They have clients who engage in particular higher risk activities as identified in various risk assessment by the VI and FATF. So when we look at SARs, we need to understand from the perspective whether or not your ability to identify a suspicion is actually there, whether or not you're collecting the right information. So like I said, most of the time people have all of the processes in place. We see significant levels, high levels of compliance on the filing of the SARs, but there are still issues which we have identified in relation to the quality of those. So it is, for us, it is very rare that we actually penalize folks for the SAR issue because they have a high level of compliance. But rest assured, if you're not actually doing it, we would take it with the utmost seriousness. We're not hearing you, Elise. Sorry.
Mute.
We're hearing you now.
Okay. How does effective CDD and transaction monitoring impact the quality of the SARs?
I think that's the direct impact. That's the start of it. I think in most in most societies, you have a type of saying in this society is, if something starts wrong, it ends wrong. And I think in business, this is the same principle. If you start, the process that you have is start off with your CDD process, identification and verification of the clients. If you start off with a very strong CDD process, identifying the client, verifying that the client is who they say they are, you identify that Glenford Malone is who he say, you have the proper ID, you have the proper verification, you have an idea of his transaction records, what he intends to do in the future, what kind of business he intends to engage in. So you have that from the CDD process and you're comfortable. You assess Glenford and you say, okay, Glenford is, from my risk perspective, Glenford is a high risk person. Now, let me be clear, that is just an example. I'm not sure, I don't think Glenford is a high risk person. But you rated Glenford as a high risk person, excellent. You've done your enhanced customer due diligence, excellent, because that is what is required. But you then fail on stage 2, which is the monitoring. So you have to monitor Glenford is a high risk. You have to monitor him. You have to know what the transaction he's doing, whether the transaction raises a suspicion. So you have your monitoring mechanisms, but you only monitor Glenford's activity every 3 years. Now, you come and 4 years from the period you bring on Glenford as a client, he has been, arrested for some money laundering activity. And immediately what you do, and this is exactly what Miglisa is pointing to, immediately what you do is you file a SAR with Miglisa, with the FIA that says X, Y, and Z. But then have you really been monitoring, etc.? And I say that to say, if you've been monitoring, you would catch it before, you would file a high quality SAR, you would engage your own system. So it's all connected. It's the whole AML regime is a chain link. If you make a mistake at one level, it impacts on the other level. What I would say across the board for TCSP's investment business and VAS, we've seen significant increases in the level of compliance at the CDD level. There's room for improvements. There's things that they need to do in relation to identification and verification on those levels, but we're seeing significant improvements. So we expect, based on outreach such as these, the next phase of that is to see high quality SARs, which, as Miglisa said, are actionable at a particular point in time. So when it boils down to it, know who your customer is and have a mechanism in place to monitor your customer and your customer's transactions. You would see from both the FSC and the FIA website, there's a number of guidance out there, how to monitor, how to look at red flags, etc. Those are very, very important to look at.
Quickly, what does monitoring look like in terms of timeliness? You mentioned that you may not monitor for a couple of years and then you find out that something has gone wrong and your client has been involved in suspicious activity, so to speak. So what does effective monitoring look like, and what's the frequency of that?
So again, it all depends, and monitoring is different based on the sector you're in. Let's use the virtual asset VAS sector, for example. The nature of the activity is so rapid, so fast. The transaction happens in, I don't know if you have lower than milliseconds, but milliseconds transactions, etc. So your monitoring needs to be effectively real time, transaction based, able to identify small and connected transactions, able to identify where the transaction is going, why it's going there, and link that back to the clients. Now, if you think about a TCSP, that may be a bit different because you're now looking at, for example, somebody who has a business company with you. So you have to be then monitoring whether or not what the transaction those companies engage in, for example, how often they may ask you for a certificate of good standing, how often they change the directors, how often beneficial ownership changes, which will trigger your type of monitoring. It also, for BVI, BCI, if for TCSP, also have to bear in mind, you have to be able to identify when the business of the company changes, and that may mean how you engage with the company. If you have determined the company to be a lower risk entity, then your engagement may be less frequent. If you determine the company to be a high risk company, then your engagement has to be yearly from the perspective of the AML legislation. And that would, what monitoring would really dictate that. And for us, that is, I think, some of the difficulties that across the sector that people face in terms of monitoring. Again, I would point people to the guidance we recently issued in relation to monitoring. What is our expectation? And again, the expectation that we have is really and truly to identify when client activity goes outside of the norm. And when that activity goes outside of the norm, coming back to the subject matter, whether that is now a suspicion. An activity outside the norm is not necessarily a suspicion. It's just an activity that you as an entity needs to look at to ensure. It might simply mean you need to do updated customer due diligence because the company or the entity transaction criteria have changed. But it may also mean that that person is doing something they should not be doing, which is where the suspicion comes in, which is where, again, internally, what are your mechanisms to identify those suspicion? Who identifies it? Who pushes it up to the MLRO? What does the MLRO do? Does the MLRO then file a proper suspicious activity report? And again, it depends on the type of activity that license you have, how rapid this must be, and how quickly it must be. But as Miglisa said, it can't be a transaction happen in 2023 and you're reporting as a SAR in 2025. That is not actionable. It must be something that is actionable, that is as close as possible to the transaction date when you identify the transaction. I think typically no regulator or any FIU would put a particular time period on it. But again, it is something when you see it, you know it, and everyone should be cognizant of the time. What I would say, Elise, from our assessment of inspection reports, the timeline between when someone identifies and files is very short. But that doesn't, we haven't been able to, and we haven't done it as yet, identify the timeline from when the initial one happens at the entity to when the entity actually files. So it might be when usually what we're recording is when the MLRO identifies and said there's a suspicion how long they take to file it. So some of these things is that we have to be cognizant of. It's really timelines as to when it is you identify the suspicion.
But Glenford, you recognize that in the virtual asset space, things are moving very quickly. It's a new generation of business. There's a lot to learn and understand. So it seems like a very tall order for the VASP sector. How do you reconcile that?
Well, the law is the law. That's how we reconcile it. I think when we grant a license to a VAS, we already make an assessment of their systems and their expertise in filing the SARs. I would actually say that in the vast ecosystem, as my team say, there is very high level of technical capability to monitor transaction, to identify suspicion. I think even in discussions with the FIA and ourselves, the issue surrounding that is how do you then file a quality SAR? Again, it's not everything that is suspicious that then requires you to file. You have to identify whether it reaches that threshold. So I don't think the issue for VAS is the ability to identify when something looks suspicious. I think the issue would be when something actually reached to the threshold, and I know that is an issue that we as a jurisdiction is grappling with in the virtual asset space and the number of suspicious activity reports.
Okay, we have a couple of questions and they're coming in. So let me switch to those. Is there an issue with the AM Live platform? Many times while trying to file, the website would go offline a few times during the filing. Is there anything being done to resolve this?
Well, currently we're in a transitionary period with AM Live. We're actually seeking to move away from the current AM Live system, and we're looking to implement a new system later this year into 2025. So that may be the cause of some of the challenges that are being encountered currently.
So they should be rectified by early next year.
That's the hope, yes.
Okay, so they just have to deal with the challenges as they move along.
Unfortunately, these are the things that comes with technology. So, yeah.
Yes. Upon filing SARs, at which point would it be justifiable that we freeze the assets while conducting further investigation?
Is it based on a particular type of offense? Do they know for certain, or have they confirmed that the suspicion is in fact substantiated? Because I wouldn't say go ahead and freeze if in fact the suspicion hasn't been substantiated. So if it is after they've done their investigation or the assessment, and they believe that there's a possibility that these assets will be dissipated, they can in fact take action to ensure that that does not happen, and then make that filing. That is if the suspicion is substantiated.
So would that direction come from you to go ahead and start freezing the assets, or would they take the initiative and start freezing the assets?
If it's a sanctions type matter, they have an obligation under the law to freeze those assets. That's legally required. It's not based on anything that we would convey to them as the agency.
Okay. What is a reasonable time frame to file a SAR?
Promptly. As soon as the suspicion arises or is formed. I know the AML code does in fact use the language promptly. It doesn't define what prompt is, but I do know that this Counterterrorism Act with respect to terrorist financing matters and terrorism defines as soon as reasonably practicable as within a few days, not exceeding 5 working days. So essentially, I would say within a few days. Once that suspicion is formed, you should act swiftly to make that filing.
Okay. In the age of artificial intelligence, is the FSC and the FIA using AI in their respective roles? And if yes, how? Is that proprietary information, Mr. Malone?
I don't think it's proprietary information. I think it's standard that all of us would use the technology available to us to make a work a bit easier. In some regards, yes, we do use that type of technology to assist us, but like any other institution, we actually looking at how that can be better used and whether or not certain, with AI, you also have to figure out the AI is owned by somebody, and we have very confidential type information, and ownership of that information is something we take very strictly. So those are things that has hurdles that have to be passed. But yes, we do. I mean, just like anyone, we do use AI to assist us in certain ways.
Meglisa? What's the FIA? How is the FIA using AI?
I won't say that we are heavily reliant on AI, but we have been exploring possible AI tools to assist us with analysis and of functions within the agency.
Okay. From a banking perspective, when a customer completes a source of funds form and does not bring in the supporting documentations, is it a custom to file a SAR because the source of funds was not verified? Should a SAR be filed or an information report form? Which one is appropriate?
In a situation like that, an information report form, because I'm not, just from that circumstance, I'm not hearing a potential suspicion. So definitely share. You can share that information with us, but file it on the information report form.
Wouldn't it depend, before you move on, wouldn't it depend on the amount of funds that this customer is bringing in, and if it's something that's not customary or outside of their customary source of funds, would that not constitute a suspicious activity rather than just an information report?
Right. So now you've added more facts to the case. So to me, that based on what you just indicated, yes, that could give rise to suspicious activity taking place. Again, the reporting entity has the obligation to investigate and consider the matter to determine whether, in fact, an external filing should be made with the agency. So yes, definitely. If it seems unusual or suspicious from the usual course of business with that client, then definitely, if they believe that this is suspicious activity, then they should make that filing with us.
And I think the question, Elise, is it's almost too general, the initial question, because you then have to go back to our discussion surrounding CDD, because in the CDD mechanisms in the code, it talks about how you go about dealing with source of wealth, source of fund, and when verification is necessary, primarily in higher risk scenarios. So it's not necessarily because I think the question says, if something hasn't been verified. But again, I would presume at the application stage, if you're unable to verify certain things, you have to consider whether to keep that person to take that person on as a client. If you're talking about in the monitoring stage where you identify that somebody's activity has shifted and you want a different synopsis about what's the source of funds, and you have doubts about the information that is provided, that is what Miglisa is referring to. You as an entity, if you have doubts, then you need to formulate. Does those doubts then raise to the level of, okay, it is not something that is a suspicious activity, or does it raise to that level and you require to file? If irrespective of the decision, as we say, and as the law is required, you then just record what your decision is. It might be you come to the conclusion it is not a suspicion, and for whatever reason you record that decision, and that decision is in writing of the record. So I think a lot of this is not so straightforward. It does tail back to how you do CDD, how you monitor, how you have assessed the risk of that individual, the risk of the transaction. Again, I think the question was specific to banks in the banking sector.
Okay, so this leads into the next question. What is the relationship between the quality of SARs and understanding of risk, including risk from the misuse of legal persons or legal arrangements in the territory?
So we are a trust and corporate service jurisdiction significantly, which means we incorporate registered legal persons. We have a significant amount of legal arrangement established in the BVI meaning trust. A number of our service providers provide services to trust and legal persons that are not incorporated in the Virgin Islands. So one of the things we as the Virgin Islands did is have an assessment of what are the risk of legal persons and legal arrangements in the Virgin Islands. And those risk assessments are out there for public consumption. Clearly, we have identified a significant level of risk in relation to BVI BCs and how they operate. I think in any TCSP or any service provider needs to account for those risks when they're making a risk assessment, when they're taking on a client. Now, here is where the direct risk comes in relation to SARs and other activities. If you are unable to identify where a transaction is suspicious, then you create elevated level of risk in relation to legal persons and legal arrangements. So you have to be appropriately monitoring. We know from experience, we know from case studies, we know from the risk that there have been evidence of misuse of BVI business companies for various purposes. Our goal is to mitigate and lessen that risk as much as possible. To do so, as we've been saying throughout this presentation, start off with at the beginning, right? You do your proper CDD, you do your proper risk assessment, you identify when you can monitor, and you be able to file a timely, high quality SAR with the FIA with all the information. Now, our expectation is not 100%, meaning that there's never going to be any particular issue that people are not going to attempt to launder money, terrorist finance, or proliferation finance. That's just the world we live in. Or the ability to identify it timely goes back to the whole issue of proper CDD, proper AML, proper risk assessment. So if Glenford is a citizen of North Korea, using an extreme example, and you have him as a low risk client, well, I mean, then you create an additional risk. And when you create a risk where you have too many poorly rated clients as low risk, you're not doing the advanced monitoring as the guidelines would require, and you're not able to timely identify a suspicion and then put it all together to then provide quality SARs with the supporting documents. So as we say, if it breaks down at that level, then you have difficulty with quality of SARs. So look at the misuse of legal person and legal arrangement report. Talks about how things like complex structures, foreign proceeds, the use of introducers, how that increases the risk, how you can mitigate the risk. And once you do those, then we would see improvement in the quality of SARs, which will become less from a defensive nature and more a nature of actionable intelligence and investigation and confiscations.
Glenford, you mentioned, I guess, North Korea as an extreme example, but I have a friend who has a 90-year-old father in Russia. And she needs to be able to have, financial transactions or whatever with him. Would somebody of that person, just because they're Russia, a 90-year-old man, be considered high risk because of being in Russia when they're not necessarily high risk, but just because of where they're coming from?
Well, it goes back to how you're going to risk assess that person. Again, we live in a jurisdiction and we represent a jurisdiction where there's significant sanctions against Russia entities. There are even sanctions against business with Russian nationals that we have to take into consideration. So yes, if you tell me someone 90-year-old in a particular jurisdiction, I may think a low risk person. But then when you add the jurisdiction, you add the sanctions, you then have to consider whether or not the risk is significantly elevated. And I could tell you in the jurisdiction, sanctions compliance is a significant issue for us in terms of us ensuring that we don't fall afoul of both UN and UK sanctions, which are applicable to us. So again, you have to risk assess that situation and figure out if it is at the level where it is so risky that you shouldn't be sending money to that person.
Okay. Thank you. Let's move back to some of the questions from our audience. Can the FIA give me a guidance on tipping off? Example one, the FIA asking the registered agent to reach out to a client. 2, staff having to confirm if adverse media relate to a client. 3, having to respond to requests for information from the FIA, and the RA might need to reach out to the client. How can the RA protect itself and advise frontline staff?
Can you repeat that question again, Elise? Make sure I get it correct.
Okay, so the question is asking, can the FIA give me guidance on tipping off and or yeah, I guess Glenford, you can jump in as well. The FIA is asking the registered agent to reach out to a client. Staff having to confirm if adverse media relate to a client, having to respond to a request for information from the FIA, and the RA might need to reach out to that client. Is that you're asking them to reach out to their client, but they're at the same time saying, give them some guidance on tipping off, and how can the RA protect themselves and advise their frontline staff on how to interact with the client in this instance when you've asked them to essentially reach out and get information from the client?
So in this scenario, is the client the suspect or the target? Because in a case like that, definitely we would advise against that, because clearly that would raise a tipping off issue. Typically, when we have scenarios where the suspect, where the suspect is involved and we may need to get information, say it's a BVIPC, we typically would not ask the RA to reach out to that entity because we are aware that they could potentially tip them off of the investigation. We would then use all powers to get the information from other avenues. So if it's not that sort of scenario, I'm trying to understand the aspect of protecting themselves if the person that they're requesting the information from is not a suspect or a target.
So what I'm hearing you say is essentially, if it is an investigation or something like that going on, you will not reach out to the RA and ask them to get information from the client. You will find other sources to get that information. So there would be a likely of tipping off because you're not going to ask the agent to reach out to the client.
Yes, if the client is the suspect or the target, we would not ask them to do that, or we should not ask them to do that, because definitely that would raise tipping off issues.
Okay.
But Elise, and I agree fully with Miglisa, but when we are involved in an investigation and we're seeking information from the registered agent, sometimes the registered agent tend to have a confusion, for lack of a better term, as to what where it is required to have. Because some of the times you write and you're saying, give me this information, and the agent turns back and says, I have to go to my client. And then what we then have to do is write and say section X, Y, and Z says you should have it.
Mm-hmm.
What Miglisa is saying is correct. We do not, and we are very cognizant of it too when we're dealing with these issues of tipping off if we're being asked for information. I think sometimes clients need to, agents or anyone, whether it's a VAS, whether it's an IB, need to be cognizant that they maintain the information they're required to maintain so that they don't feel that they're in a position to tip off someone because they now have to go back to a client to ask for information that they otherwise had not asked for, though it is required. But I agree with Miglisa, it is almost, you would never ask a question about someone being investigated, which requires the agent to go back specifically to that person. If we ask questions like that, it means then the person is not necessarily a suspect at that point in time, for lack of a better word.
So how do you respond in the situation where you have requested the information from the registered agents? It's information that they're required to hold and not have to go back to the client for, but they don't have that information, what would be your response in that regard? Because they're not doing what they're required by regulation to do.
Well, for us, that is a referral to our enforcement folks, because it's a breach of the legislation if you're not ability to provide it.
Okay. So we'll move on to the next question. In cases within TSPs where adverse information is found, for example, a conviction, but our records do not indicate that there is a suspicious activity, should a SAR be filed or an information report?
I'm so sorry, Elise, can you repeat that question?
In the case of a TCSP, sorry, where adverse information is found, for example, a conviction, but their records do not indicate that there is a suspicious activity, should a SAR be filed or information report?
Yes, definitely, because we do see those sort of filings, and more than we would like to see them, from TCSPs in particular, because they would, and to us, I know we haven't spoken about this yet, but that to us would be a defensive filing, because when you read it, it's mainly they would take the information from adverse media and put it in a sign, send it, but they don't explain or indicate why this is suspicious or anything of the sort. In those circumstances, that sort of information should be shared with us on an information report form, because there's nothing for us to act on in a case like that.
Okay.
But Elise, I would say the entity needs to be very, very careful here, because what we're talking about goes back to my initial point, CDD, monitoring risk assessment. You're saying you've come across an article or some sort of evident information that says one of your clients have been convicted of an offense. That should trigger a lot in your mind. That has to trigger a review of the entire business relationship. It has to trigger what does that finding means for you and the client's relationship. It should also trigger, again, whereas I agree with Melissa in terms of the genesis of that, that is just simply something for information. Your investigation as a TCSB into your client's transactions then has to really then be determined whether or not something suspicious has occurred within that business relationship. If someone is convicted as an offense, then I believe you need to give that some significant thoughts about the risk of that client, the risk that client poses to the jurisdiction, and whether or not that client is a client that should or should not be maintained. So it is, to me, it is wider than just filing an information submission to the FIA. It is really the MLRO and the compliance officer or senior management really sitting down and figuring out what you need to do with this client. So it's a bit broader than that.
Okay, the next comment, I guess, is related to our earlier conversation with regards to unusual activity. And they're saying that unusual does not always mean suspicious. Unusual means we question further, investigate, and then decide if suspicious based on the information that has been gathered. Is that correct?
Well, yes. I would say yes and no. There's always a caveat because the monitoring guidelines just talks about, but you need to be able to identify when a transaction is unusual. I think the issues that we face that ends up impacting the quality of SARs is by the time someone identifies a transaction as unusual, as Miglisa said, it is 2 years ago. And that is not helpful. So you have to be able to identify it. Yes, you identify an unusual transaction, you look at it and you say, oh no, this person is perhaps engaging in a transaction for a high value activity that he don't usually do. That is fine. So it's just a matter of your ability to identify it and then look at it in the context of the risk the person poses and whether that risk comes to elevated.
Okay. It is reported that from 1st January 2026 that the AM Live will be the official reporting platform, but you indicated that you're moving away from the AM Live. Explain.
Not moving away. So we're currently on an older model of AM Live. We are basically with the developer is implementing a new model. So it will still be AM Live. But that's why it's going through a transitionary period.
So it's AM Live 2.
It's AM Live, just a newer version.
Okay. Therefore, when information is sought from the RA, it is not an investigation. I guess, again, referring to the earlier discussion, when you're seeking information from the registered agent, is there an assumption that it's not an investigation? Because you would not go to an RA when it's in the process of an investigation? Can that assumption be correct, or?
If the agency is requesting information from an RA, it's typically to assist us with our analysis of the matter. What I'm saying is that if the entity is a suspect or the target, we won't ask the RA to get the information for that entity. We would get the information from other sources. That's the point I'm making. But it's all the information that we request is all to assist us in our analysis.
Okay. From what do you do with high quality suspicious activities reports?
Okay. Typically when we receive any SAR, essentially, that is high quality, low quality, we would triage our SARs or risk rate our SARs. And how we do this is we look at the SARs, maybe we could look at the type of offense. If it's a money laundering matter with large sums of cash involved, domestic corruption, breach of sanctions, TF, PF, those sort of matters are high priority matters, or they will be risk rated as high. We may have a regulatory breach. We will risk rate it as a medium risk type matter. Once a SAR is risk rated high and medium, we would then assign those to the analyst for to conduct the analysis of those matters. Once the analyst receives the SAR, they of course would review the SAR and determine what next steps to take. So they could possibly consider our database to see if there's any information on our database, previous SARs filed on the subject. They could consider open source tools. They could also utilize our Section 4 powers, which we were talking about, in order to get information from RAs, from banks. Sometimes we would request information from foreign FIUs, government entities. So it's about collating all that information and then being able to review that information, analyze that information by the use of analytical tools. Once they've done their analysis, they would then determine whether in fact the suspicion is substantiated or it's not substantiated. If in fact it's substantiated and there's further action that can be taken, we would make that dissemination to law enforcement or any other relevant agency as deemed necessary for them to conduct or take action on their end. If, however, after the analysis, the suspicion is not substantiated, we would essentially send a letter back to the entity and indicate that, yes, we've reviewed, we've completed that analysis, but we're not taking any further action at this time. I forgot to mention, for the cases where we do make disseminations, we also inform the entity that we've shared the matter with the relevant authorities to take action on their end. And then we will close off the matter. So that's the process in a nutshell. Of course, it would vary depending on the circumstances of the case, but yeah.
Some years ago, we were having challenges with, I guess, opening bank accounts. And on investigation, it seems that if a transaction involved, let's say, 3 or 4 jurisdictions, SAR was being filed. Let's say a transaction involved New York, Hong Kong, BVI, and London. A SAR was being filed in New York. A SAR was being filed in London. A SAR was being filed in BVI. And a SAR was being filed in Hong Kong. So it increased the number of SARs for that one transaction. Should SARs be filed on complex transactions, and it actually increased the risk profile of us as BVI, as a jurisdiction for that particular financial institution. So it worked adversely while it was the same transaction, but happening involving multiple jurisdictions. So should SARs be filed for complex transactions that not just involve multiple jurisdictions, but just complex transactions in general, and just give a comment on to, what transpired with us with a particular financial institution and how they were filing SARs.
Okay, so you say complex transactions. Does this involve complex structures, or you're saying it's complex because there were jurisdictional elements within
Structures, yes.
structures? Okay, so for me, because it's a complex structure in and of itself, it wouldn't automatically, in my view, or shouldn't automatically trigger a filing. To me, you have to assess it. Are there red flags involved, things that raises suspicion? For instance, movement of large funds of sums of monies with no economic rationale or reasoning. So things that would raise that suspicion. So the complex structure in and of itself, yes, while we know that these can be used to obscure illicit activity, all of them don't facilitate that purpose. Some have legitimate purposes like tax avoidance. We know that's not illegal. So to me, it's about assessing if there are other factors, if the red flags involved, then that would raise that suspicion. Then I believe a suspicious activity report should be filed, or suspicious transaction report.
Okay. So how do we, and this is a question just generally, so how do we respond to a financial institution that has increased our risk profile because one transaction, although it's complex, has multiple jurisdictions involved in it, including BVI, a BVI company?
To me, it should go back to the same thing Glenford was talking about, them being able to know their clients. And I believe that because it seems like they're probably not aware, because they're probably saying, okay, it's complex, so therefore this should trigger suspicious activity. But I don't know who would inform, but I believe that comes down to educating them and understanding that there's more that you need to consider before elevating a risk for a particular client. I don't know if Glenford wants to weigh in on that point, but that's my thoughts on it.
But I think that let's be clear about the requirements. Wherever whichever country that transaction touches, once there's a suspicion, there's a requirement to review that suspicion and file. So the nature of BVI business is cross-border and multi-jurisdictional. So if you have a complex transaction and that transaction is deemed suspicious in all the jurisdiction that it touches, then the entity in those jurisdictions that actually facilitates a transaction would have a requirement to review it and to file a suspicious activity report if they so deem. So I don't think it's anything that we as the BVI can actually do. It's it goes back to the initial point. If you're doing proper CDD, if you're doing proper monitoring, a complex transaction does not mean a transaction is suspicious. A complex transaction could simply mean that you, as the TCSP, the IB, or the VAS, fully understands your client and knows why that transaction is being done, the rationale for it, as Miglisa said, the economic benefit of it, and you're comfortable based on that assessment that the transaction is a legitimate transaction. So complexity is one factor to consider, but it in itself does not mean that the transaction is suspicious.
We've been hearing some, I guess, concerns that, particularly in the virtual asset space, because the FIA has reported that you've seen quite a number of suspicious activity reports, specifically in the virtual asset space. But we are hearing from the industry that there are concerns that some of this may just be a defensive filing with respect to the SAR because people may not understand. So if I don't understand, let me just file a SAR and not get in trouble with the FIA. What does the FIA consider to be a defensive SAR? And does the FIA have any guidance on preventing defensive filing of suspicious activity reports?
Okay, since we touch on the vast sector in particular, in reviewing VA SARs, I would not state that those filings are defensive, because when you go through the SARs and you read, there's actual suspicious activity taking place. For us, a defensive SAR would be what we spoke about earlier, adverse media. You just send in the information. Is because, like, you have an obligation to file. There's no suspicion, but I'm going to file nonetheless. CDD. To me, those things are defensive filings because there's no suspicion involved. Guidance. We don't currently have guidance on defensive filings, but it's something that we can consider issuing if it would assist the industry, the industry's understanding. I can also maybe provide some examples after this session, Elise, to you in terms of defensive filings, good examples of SAR or quality SARs for virtual assets, TCSVs, the high-risk sectors, if that can benefit the audience.
So you're in disagreement that the SARs that are being filed in the vast sector are not defensive filing. They're
No, I wouldn't say they're defensive.
genuine suspicious activity.
It is what I would say, and just speaking on the defensive guidance issue, technically there's guidance on filing of SARs, and it does contains information surrounding when you should file it, what you should be looking for. There's guidance on monitoring your activity, and all of those are effectively guidance on preventing you from having to file a defensive SAR. Because as Miglisa says, if you just see the news report that your client is in something and you just file without properly setting out what's your suspicion, yeah, that's a defensive SARs. But if you go back to the guidance on filing a SARs, it tells you not to do that.
Mm-hmm.
So you have to, there is guidance out there that should assist the listener as to how to file a proper SAR.
We're winding down, so if you have any more questions, please feel free to put them in the Q&A. So before we start wrapping up, I'm just going to ask, how should training be provided and on identifying suspicion, and to whom should the industry be providing that training to?
So for us at the FSC, when we do inspections, we look at the training provided, and specifically training should be provided to front level staff who deals with the type of client-facing activities, as well as AML training generally to the staff within specified period. Again, the issue is really how do you train your staff in identifying something that is suspicious? What is you as a company, what is your threshold? What does something suspicious looks like? Again, we provide guidance on red flags and all of these things, but those are just guidance. You as an institution then have to set out, well, I am for example, I'm a broker under IB. My suspicious red flags look different than if I'm a fund administrator or if I'm an investment manager, the flags look different. So we expect to see training specific to the class, the type of entity, type of business that you are transacting. And again, timing of the training is very, very important. We shouldn't be coming in and seeing that you're providing training to staff every 2, 3 years. There should be annual training to your staff in relation to AML regime, in relation to the filing of suspicious transaction report, etc. And this includes senior management and the board.
How do you train the trainers?
That's always a good question. Quite naturally, someone has to know what you're looking for. What we tend to do is we put out a lot of guidance. We do some of the training ourselves. There's a lot of training institutions out there. And I think in many of our institutions, the trainers are either the MLRO or the compliance officer. And we tend to, these are both are now approved positions. So we tend to look at the qualifications of those persons and make sure they suit for purpose. So we would expect those type of persons to have the gravitas and the skills to do some of the training or to take steps to ensure that the training is properly facilitated by the institution. So those people are effectively the trainers to some extent.
Okay. Like Lisa, any comments on that?
No, I agree with Glenford. Definitely.
Okay. Before we wrap up, this has been a very interesting and informative session. I'd like to ask both of you to give your final words on suspicious activity reports, your expectations going forward, and how we can, improve the suspicious activity reporting requirements or obligations. And as a jurisdiction, how does that help us going forward as a jurisdiction in terms of meeting our obligations for our requirements with the mutual evaluation?
I'll go first because I know I'll be shorter than Glenford. I just would like to say that I hope that the forum has been beneficial for the audience and that they have a better understanding of how to file quality SARs and the importance as to why filing quality SARs is important for the jurisdiction, and actually being able to not just analyze and file, but to potentially get cases out of these SARs. So that's all I would like to say, and I thank the audience for listening. Glenford?
Yes, I'll be a bit longer than that, Lisa. So listen, a good quality SARs is a good output for us so we can get to the outcome we want. And the outcome we want as a jurisdiction is to mitigate against ML, TFPF, and other financial related crimes. That means for us to be able to take the proceeds out of crime. And that means all licensees, all entities go back to square one. You do the proper CDD, you do the proper risk rating, you do the proper monitoring, you identify the suspicion, you do the proper training, you look at the guidance that we have provided. At the end of the day, none of us, I mean, as a regulator, we're not necessarily in the business to penalize people for non-compliance. Frankly speaking, from the mutual evaluation report, we want to see significant compliance. That is a benefit to us. That is a benefit to the jurisdiction. We're not looking to raise money in relation to people being non-compliant. We actually want to say to the global standard setters, we have looked at our higher risk sectors, TCSPs, investment business, and VAS, and they have significant level of compliance. Here's the evidence. We have done X, Y, and Z inspections. X, Y, and Z percentage of persons have been deemed compliant or largely compliant. We've looked at suspicious activity reports. The qualities have increased because here's the number of disseminations we have been able to make. Here's the number of investigation. Here's the number of prosecution. And finally, here is the proceeds that we have taken out of crime, meaning confiscation and forfeited from the proceeds of crime. So for us, it is really continuing to demonstrate that we are effective as a international financial services center, and that the persons that we have acting within this sector are cognizant of the risk and taking steps to mitigate the risk. So, and I thank everyone who has attended this seminar, and it is be beneficial for both us and the attendees to continue on the progress line that we're seeing.
Okay. Again, I have to apologize. It seems that we were not able to rectify our glitch. I'm not sure why it happened. It's the first time it's happened where it's put a cap on the number of attendees. So we will be circulating the recording to all the persons that have registered, but I am going to ask the indulgence of my guest speakers today to come back on a BVI Finance Forum. I'm not sure how soon that would happen. I know Mr. Malone is a very busy man, and so many times I try to chase him and get his availability. Melissa is also very busy, but noting that this information is important and we want to get the information out, and people have an appetite for consuming live information, yes, we will make the recording available. So I'm going to ask if they can come back as soon as possible. I'm not sure the availability next month or January. I know some things I've asked Mr. Malone for. He told me he's not available until the second quarter in 2026, but I'm just going to see if he can squeeze in some time next month for us to have a part two of this session, because I think it's very important, and we apologize for persons who were not able to join. So can I get your commitment for part two?
Well, all I would say, Elise, is you have my commitment that we will continue to use BVI Finance to get our outreach done. And we have a number of outreach on the agenda for end of the year and next year that we use. I can't commit to the December because, yeah, that's a very, very tight time frame. But this platform is a platform. We will be utilizing this platform for several other topics. The FIA and the FSC has agreed certain joint outreach in relation to SARs, because this is just part of all of the outreach that we want to do on SARs, because we want to keep it in the minds of licensees and persons, and we want to be tracking the quality of SARs and see improvements. So I'm not committing, but I'm not decommitting either.
Okay. Fair enough. I'm still waiting. Miss Cupid.
I would have to concur with Glenford. Yeah. Yeah.
Okay, my time is also very busy, but of course, like I said, this is very important, and we will make sure the recording is available. I want to thank the deputy I want to thank the Deputy Director of the Analysis and Investigation Unit at the Financial Investigation Agency, Ms. Meglisa Cupid, and also the Deputy Managing Director of Regulation at the BVI Financial Services Commission, Mr. Glenford Malone, for providing us on how to turn our suspicious activity reports into game-changing intelligence. This has been another BVI Finance Breakfast Forum. I am Elise Donovan. Thank you so much for joining us, and we hope to see you again at the next BVI Finance Breakfast Forum. Do have a pleasant day, and thank you all who joined us and for asking your questions.